for Yamamuina Ache Edamase, and ne ayene, ye catch mo say, Bosumi ni da ye tosso and nine, and now Obenimbo Sumeno say Tridiam for Dumye, Nani da a tosso nine no, enu, near yet in Comte Chamada Bojim, and Moje dear Murphy Sania, a ye or my ganemu, or may ya send Nibia Cassie, Judgment Day, and I say Bacansa Timuda, Edia, Nancy, I see a woman say. Afimpinu ene aduonu o man Ghana kwa abato so sene o man nimre kuni echire wa abra ye ko ye ne yeto aba ne wieye echiri nsemu a eba ye nsunsanso eba ye no wo omayi emremu no wo ma ye wo se party binya anase wo binya ansane atumi aka se wei obetumi adi o mampani dada John Dramani Mahama wodi NDC amanyoko nanim tu franka ama wo ma yenya ne ntie se ensunsanso eba ye no entwa yie ema wo hanchemu aduonum ene baako ye wo se obi enya ansane yetumi akase wo mampani no aba no sane niema sikoye ene wo nkontaye amanyoko na wodi animu no wabuo no wo betumi akase mampani na na dodanko akufuado ya wo bo ni din se wo no ene mampani wanya etimpanifo enhwe na chese abano yensan enkotu bio mekase mpanimfo nhwe a wonamra kwa so eti wode ko omeya se nibia kase Supreme Court abusuan ye didimu na nne ye de adu babia ye duru na babia hye ase efiri ye ene babia enne ye duru no enne ye bekum ye bebu nkenta bi ye ne a lawyer fo bekasa na ya hwe na ye se adwane de ye nante se ene mabɔ ne tofa no enne ye hwe animu se ajeje fo maako nson ye asem no ekoto pono so ema Chief Justice di animu yi wo sa asem no mo na mo betena so meso meka ho bi no enne en wode watemuo eba na atemuo no ye hwe animu anya bia aba no ye besa atobie ewo my Ghana mu rerun eba na because sa wo hwe requester anasa desrede a mampani dada John Dramani Mahama wode court no a emu ba akono no sese obi anya wo hanchemu aduonum ne ba akone de a ene na wo sa aba no ye san akoto bio enti ne ruling no beko in favor of petitioner no ye mampani dada John Dramani Mahama ama ya san akwa akoto aba ne biem ana se anoyie ya chese mampani nanado woni isifo de koye se na niema mu da ho no mukrogen no eno na ebe ye adwuma ama mpanimfo aka se mampani nanado wontoa na adwuma so ana san ene ye beko no abusua ena ne ye hwe animu ani ti no nkono aba pamu no enche se mpanimfo ni nya betena se no wo hye ase se wo soesha adwen a ye dem live wo Adom TV Adom FM Asempa FM Hwa FM ye ne affiliate stations aworo a aka nyina no se wo tie ye ne a ye be mo wate atemuo no san na mpanimfo beyo no a wode beba wo declare de na bekoso se say ye di kan nya ntie mampani dada John Dramani Mahama wadu court ho no mo ene wo ko waboni suit mu dendendende wo kwa akotie nsunsanso a aba electoral commission no ba pani ya woda no ma meje mensa won so awura court ho no mo a lawyer fo a ejina mu ama nipa akuduo miensa ni nyina da so wonum so adu court ho no mo eti ye hwe ni mu se judges makomako enso no so wode wano asembe kwakotudwa ne Ghana fo twen ya no yese ne yefun woje ya ne de omen nanso ne abusua se yesi adwa na yadu mpempenso a yadu ya mame nkai wo se eyeye manti enye yenti oman Ghana yiedie sebeyo na kabi mame nkabi amamuo no yebenyini na nkakra ye koye nimuo no enunti ana multimedia adwumako ye de age ato ye ho so se ne yebemu man na kwa animu bia no ye de akire ye to santia hwese ne eniema siko eti na so abusua yaba medin akua boachewa yi Adom mo frami ebiwa meje so enyuma no ehye ase se obeso yemu no wo se enne makomako aduana mienu no ne ya na ekoro ti ebedu si enu no enne ha ne yaduro yemfa seda emakoa mixture kane poa FS ene se ne yadi boost immune system aduro ba akopɛ ne aka no ye frɛ no koa mixture kane na di enda so eye koa FS na mpanimfo a woyo ye no wahyada akekan haba na niema bom Food and Drugs Authority fo age atum ene wode abadwa so nti wo nom wa wunsuro wonum so anum bie di adanse se ebo immune system no ho ban eti abusue aduro no eno ano no koa mixture baby ato ne aduro bia wo kwa no wabisa wure fia no akase kane koa FS no eno a ene yede bema wo ene yede aseda so ema petrosol Petrosol adwumako baako a ye ka fam wo hu dwadie ewo mayimu na akwati woni a wayera wo ye drobani na wo twu kai no a udu Petrosol agina ho ne yemu ne ma wo se sika kakra bi na wutua esa ase wo hwehwa wo mfidie no eti kakra bi no wo bɔ no ma wo na wo kro no na wo mfidie no so se ne wasi aye no wonye no adjustment ye adjust no eti ubehwe no ubebuobuobu enye mada Petrosol ente saa ubusu a unyi ne kama ana ye wo DBS mixture da bi o ampadu bekume ye wo DBS roofing sheet ye ka DBS roofing sheet abusia enchance fafa a ye de bodan so no eno no enchance a ye de bodan so ya so onya de kuru dan no so wi a wo how to atwa efise wo nananum beba na nankanso abeba na enchance ne da so ye mo no na ehia ne sensuo beto na enchance na dwa ne ho edware ne ho nti ubu color na red da bia red kama ena sese wode alozin tracis aba eno ya dade ye de bo nchense so tu de dade no bo so na de nchense ni guso a wo hawa febo etu atwa enu biribi manko yi nsa nkobo so bio wo hwe DBS achi akwan a Sprinter Road oni papa restaurant na ene di anim hwe busia enyuma yi ena ebo ye chidom ene ye didwumadie ebrew na me yenhyasie mfiri baabi ansa na mpanimfo besi adwa ebe kokoto no yenhyasie emfiri ni sei ye hwe baabi a ye hyasie firi ye enne ye de aduru baabi a ye de aduru abusia se nyina ye beka ye ho a omanyi abakosemu ene omayi entotoye a ye famraku ni ho no efiri afi apema henkunu ediokunu mienu ye oman Ghana ye hyase se kabimami kabia mamuo ene ye bedi atumwo from 1992 yeah kabimami kabia mamuo no ye de hyase no ne ewomu a ne se enye se bi aban bi tiso no obi bu afunu akwakotu na gubiem ewo sese emfie na bi adura Ghana fo di kokromoti kokoto aba na wayi asomasi wo bentene anasa amanyoku we ni akase sa amanyoku we ene bebu oman Ghana eti yeto aba no a 92 96 2000 2004 2008 ena 2012 ena nkakra 2016 ena fi 2020 yade kwato ye etu tim se ye tu kwan ye kase oman bi kabimami kabia mamuo no wagye atum ato aba edikan ne yetoso mienu ne yetoso miensa ne yetoso nan ne yetoso num ensia enson wotwe na ese yakobi na afimpinu ani dumienu mu sane ye meka ya abato no ne yato abeduru no yeto aba ni wie ye no ene ba ne se nipa sabre no wonumu epre no wo mu baako ye mampani na ne wote so mampani dada da bi sabre nkwa de no wonye mampani na wote so na nadoda nkwa akufuado wo yo se da bi aba no ayeto ye no wonyi nisa niema ekoyie eti sabre no ne yente Supreme Court so obi akọ Supreme Court ne ate se yeto aba no 92 eba 96 mu wonom no wahu ni NPP for stolen verdict wonum twroye yeto aba na wie ye bonyo so court amam na emom ya twro nwoma bi a kire se eniema ntwaye eti 2012 de ne de na abaya abakosem se yeto aba amanyoko bi bu anyoso nipa bi bu anyoso nanso court en wode kro Supreme Court mpanimfo kwa setena sabra ni enim mra bia ne hyehyeye bia se court no kokotena se a ebia enedu enensia na wose woto ewi wodidi asem nu awie eti bosome maako nwotwe konkron na court nda so ti asem no so ama mpanimfo di asem no a wo wi ase no ye beto odwane se ne akwakodura nipa wodi nkunim sabre no mampenda da John Dramani Mahama wono a na wose wotena so na emum ruling ne baaye no recommendations bi baaye ya anya se court no ka so ne wote so nto aso ne baaye ne se ya nyansa kira ye wo kwan ye fa so to abanimu eno na brofu mu mpanimfo de tu dwa say ye ka ne say recommendations as Supreme Court de by electoral reforms ene ye hu se nsa kira ye aba eno amu ne nachi 2013 kro no ene ye hu se da bi ewosan sachira ye ba na bere kura se ye to abawie na obi bonyo so a court no de tenase no ewosan sachira ye ba adwenkyere ko so e ma mpanimfo de wadwen ba nu na besi se ye to abawie na se akua bo achi wa yi Adom ana se Kofi Ampadu na ne bo anyo so a wode asam no koda court a ennem maako aduana mienu was asam ye tumi di wie nti won say die no enkwa bosome nwotwe nkwa bosome nkono ye se nde eye da ye di ebu aten no ene ye di duru ha na yemra yanim ne yemra fimpinu ene aduonu wabra ye to aba ne wie ye no unim se bosome ye bosome ye twato no ne da ye to so nson ene o man Ghana ye de to aba ewo mayimu ye to aba ne wie ye no isi mpanimfo ansakora ne ye beto no mu no wo ma ye nya ne nte ye se ye to aba ne wie a acha no be da ko akidie wo se wo bobo ema obi ye hu ba bi a wogina eti ye to aba ne wie ye on the 7th on the 8th ya antehwe on the 9th fed ye wo mu a na mpanimfo ye so bere no ahye ye be bobo ne ye wo mu a ene ye TV station ye de ato ye be bobo na ade na to afa ho saa nkakra eso on the 9th no mpanimfo bobo abato no ensunsanso no ema Ghana fo nyina TV ensunsanso no eba ye no ena NDC amanyokuo ya mampani dada John Dramani Mahama di wanim ka se da bi ne bu nyo ensunsanso eba ye no so eti ye di kan hu demonstrations ahoro ye course protest amanfo bi eye ene ye wo mu a wo bete ye se ba bi ti se Savannah region bibia koso enkran ha bibia koso Asante Mantem demonstrations akoso ene wo manfo adi nsuohie gu wo so electoral commission wono mo ni nyina akoso e na edu mpempenso se omayi mra hyebadwafo mpo mra hyebadwafo eto santin firi mra hyebadwam sa wo ba electoral commission wono mo ene ye wi ase busa mra hyebadwani wonu se ye piepia na ma mida fom tim eti ba bia na ne mekeka ko na ase da bi o mra no wo ho no eno da nchen ena nipa bi pese wo de mra hye wonsam ana eti ekuduo bi hyase se wo kasa omanyi mpanimfo bi ene ye weyi ana wo de aba wo bonyoso akokoto obonyoso akokoto yete wono mo an yete se mampani dada John Dramani Mahama afedie waba abonten de atudwa se abato ne bo anyoso na ne bo anyoso no so no omaya se ni bia kase Supreme Court wo eti wobeko ensemu a wokuchi gu nkrata so edi court na ni mefisa ansa na abeko court no enya se wote da se abra no ama akora so wo se wasam nti a wo se court ne tena se no wuchirem digu nkrata so na mpanimfo so ahwem se obedi atumu a na chese yakoyanim saa court kro ya mampani dada John Dramani Mahama ko ye nyina no medika ka che say electoral reforms ye ba ye after 2013 court ruling ye ba ye muo no na chese ni nyina agina so court no e kire ye to aba ni wie na abo anyo so a enna dodo ye wo sedie ye wutumi kokoto wutumi de wasam kokwan ye wo so fa so nyina eti mampani dada John Dramani Mahama kokoto no okoye no asemu a wode top no sukuruchi ede koye no abusua ebi eni ye kan na chese brofo kasem petition no sa wo hwe ye wa Adom TV live on Facebook anasa Adom FM a wo be se ye de petition no ensemu a wogina so court no ye de ato kasamfonyi ni so na wo a wo hwe no mami si mubi emaw ne edi kan mampani dada John Dramani Mahama asemu odi tudwa ene se abato no a yeto ye no nipa agogina epre ye no wo mumu bie ni honomo ya wo hanche mu aduonum ene ba ko ye omayimra kuni hyese ewo so obi nya ansa ne atumi aka se wei betumi adiga na man so no obi ani honomo ya wo tumi enya saa emma no ne edi honomo bie ya achese wode ho asemo atudwa eye se esan se wono wo munku ntabuo mu no wo hu se obi anya wo hanche mu aduonum ene ba ko ninti no empanimfo nhye mampani na nado a saa bere ni wote so odu ba bi asa ne obekari ne ho se me ye mampani no kanu no wonya akora because wono ne wo kan se obi ani nkunim ewo mu ene wo kan ya asa de besi vote pardon se ye de mani bi aka wo bi de wonsam no de abusua na do so na maka se ye de ato wo no na saa nsem we ye ode betu udwa no de tudwa wie a na wonwie ye ewo se kotokoto nanimu a nipa wo bo wo kwadu eti ese mamu ohun se mampani dada John Dramani Mahama any petitioner no ana se wono na asem ha no wo de akokoto eti hifo no wo bo wo kwadu no nipa wodi kan ye obo won kwadu ana se dwuma wo bo wo kwadu eye electoral commission ya wona o mayimra kuni ehye won ema won tumi se ye beto aba bo mayimu a woni animu eti na se first respondent no eye EC anasa electoral commission kwadu wode bo won ana second respondent no mampani a wote so mampani na nado so kwadu ni bi ekọ se yaka se EC wonum wadwuma no wanye ne yiye wanya wo hanche mu aduonum ne baako ne yese wo mampani eti wo so kwadu ni yede bi abọ enwo se o kari wo se mampani tina mampani na nado second respondent na ba mu enu achi no na wo se nipa no ayabo wo kwadu no wonum so de ho anu yiye eba na afei court no so obekọ wanim so obekọ sen no yatumi akọ eti anu yiye no abushia eba ye mampani na nado second respondent no wode wanu yiye ekọye ena electoral commission first respondent no so de wanu yiye ekọye se wutie sa kuhudu ana se nipa mienu nyina EC ene mampani na nado obi ade ode kọye ne se asam no petition no de kọye ye mampani dada John Dramani Mahama no ensuo nhede nyina mu asam no enya asam a wo se enka court no kura wo se wo bere se wo tena so we ye EC for ne state wo wayim wo se onkrata mu se dabi asam no kura mo de abansuo bi anyina mu tiba mo nse mo bere kura na nka mo enkotena asam no so eso empanifo hwemu no na wo se asenie no ba na bantia no yie no first respondent second respondent obia de ne de ekọ eno akọ akogu ewieye na wo se empanifo etena se wo siginaye ewo asenie no kwan obefa so akonu mu abusia ye bekọ no so na makacho se na ye ne a lawyer fo nkitaudi a ye de ba nyina no ye bekọ no nkakra ye be mu hu babi a ye duru babi ye sha ase efiri ye no an ye guso a ye komu no ese court no so asetena mu anu yie ba ye nyina mu no NDC amanyoko ni sabusia samani di akire a wa bere ba se wonum de won krata no kọ no emfonso kakra ba mu ya eduru ba bi no nanka wo se mpanimfo ni sisu dua se abato no yensan entu ni bio between mampani na nado ene mampani dada John Dramani Mahama no wo kan won krata na ne ba ye ne se yensan tu abani bio between electoral commission ene mampani dada John Dramani Mahama eti edu se wo court wo de di kan ye kọ ye no na wo se amendment ba anasa mfonso no e ba ye no wo ye ho nsakira ye na nu achinye kakra ba ye emu ho se dabi o wo enhyehyɛ ya ye hyehyɛ ye after 2013 wo di asem no court wia no wo nipa kro ntimi mfa asem no nkoto court wo na ansan enkoma ye mfonso misiesie ma ye mfonso misiesie na nso no wo abra mpanimfo ekọ se wo pese wo siesie wo mfonso no panimfo ma wo ho kwan se mfonso no ye wo mfonso ebeka se o mfonso we nipa no bo apayom ene ba ye ana se afidie no kra ye de type no wo so tumi ma mfonso ba eti akwanya ba ye ema chese mfonso e ba ye no wo siesie ye petition no afem eno achi na petition no lawyer san so de ade se de atu dwa se asenie na mpanimfo obedi no won pese be ye kokoam se bia ye kwhye kokoam ni aka na ewo mu ana ye de bia betu dwa na nsentwerefo ati yenye magana fo nyina nhwe bi saabre na court no so kure di kanya fa adwen dada efise mra efa sa asenie yi ehwo no mpanimfo se court no wotumi se wo kire se asenie no ye pese ba badwam ema obi ahwe bi ana se ye mpenisa nti na court no se o ye kura no sa adwen ne afa dada ebeba petemu ama Ghana fo obi atumi ahwe bi anu nti na ne ya TV so a chese ye yi a ne ye de atudwa na wo hwe lawyer chachuchi kata de ne atudwa lawyer Kotwampa de ne de atudwa lawyer Justin Amanuvo na chese obi e kana wo tibi efiri ho enti ne yaduru ha se yi no abusuan me enko mma so na yen hyase ya lawyer fo ene wo etwetwe nko ma me hwe lawyer waba ahoma no so na yentumi enko yanim hello lawyer abusuan yes. Lawyer hello. John Agbote yes. Lawyer John Agbote eni ensaka no lawyer mo anofeisa wagie so aba Adom TV Adom FM Asempa FM ena Enhye FM so me gidi se bibia aboko de
boko nyame adom ni aba
yo ye de nyame ase anopai baby a ye free eni baby a ye duro ene nipa nson anase atemuafo nson ya wotena ase ene se ene ye atemuwo da eti Ghana fo ye wa atwenye mu ya hye ase ye bubo bi hin ye free hin ye atumi aduro sabre ya keka ka bia ye kan matiefo ate ase lawyer ene no ne ye hwe animu ni se yenya wura court ho no mo a na mpanimfo no wode atemuo no atudwa ne apone anase adru saa da yi a de na tumi sie wo court
yo medase ene de a aya judgment day de wo ho ane say omo nya kodo ho a na court the judgment a wo no na o de atudwa na judgment no and also depending on amboa judge no aboa modeba je court ho
yo lawyer lawyer Mr. Albert waso ma wo camera no emra form kakra emayen wo camera no ma emra form kakra mayen na eja yentumi aha mo pacho to aso mayen
yo the American say amboa ajagifo no aboa no na ebe kire de omo ba beye omo betumi aka say okay ene ye nwe judgment no ntino ye the highlight ba betu that said ye papa to go ban ne nkrofo no ye no 2013 no enti amo the highlight ye be gbadegbe no abo atugoba no abo ansa no abo we na issue by issue owia na the final conclusion no to ho na later amo the judgment number and I say na ye ready a court no betumi aba aka say okay na ye ready yeah, kind enough from cover to cover until be antie bi. And I say, na ready there, but yeah, the highlight never back. Now after no obi able to me akọje copy now I kind. And these are the three options.
Eti sa uka highlight no a eye atemuo no ne mpanimfo no atwero ene obedi kan abechie mu ama Ghana fo atie se ye atemuafo nson ebia ne justice mafusa de tu dwanie ne justice mariama de tu dwanie anasa sen highlight no chemu kakrama ye na ye nkoye
o say issue by issue issue no bi ne say omo court no na nyama omo wa asem ana ba ko ne say yi declare the results no mfonso aba ho ana
okay
na say a third one ye mfonso na aba ho no ye de the Chairman South e ka ho a anana do obenya 50% plus ana and no sa no be no nti of first issue a we be a judge 1 or agree say judge 2 and
say ya bobo sister yo lawyer we Zoom panelist Mr. Wada ye ne wa nti yenko ne yenkohwe mpanimfo no aba na ye mpese ba kokora beto fo mu a yenche yenko na yenkohwe mre besan ba osu bio lawyer gote yedase
mate
yo abusia mpanimfo no anya aba uti wo hwe yen wo Adom TV so utim se ene obia hye ne che no obia hye na taade no mpanimfo betena se yentie ne eba ye ba besan to aso medin ABY.
Your Lordships, please, I appear for the petitioner, and with me, my learned friend, Tony Litha. May it please my lords, Justin Amenuvo appear respondent with me, AA Somoasa.
Akutuampa for the second respondent. My lords, with me are my learned friends, Frank Davis, Kweku Srifi, and Yao Pong.
By court. The judgment of the court is unanimous and same will be read by the president of the court. Petitioner, who was the presidential candidate? In this amended petition, hereinafter referred to as the petition, the petitioner, who was the presidential candidate of the National Democratic Congress, NDC, in the 7th December 2020 presidential elections, is seeking 6 reliefs against the Electoral Commission as first respondent, and the presidential candidate of the New Patriotic Party, NPP, as the second respondent. The reliefs are in the nature of 3 declarations and 3 orders. Aside of relief Ye, which is praying the court to restrain the second respondent from holding himself out as the president-elect of Ghana, all the other reliefs were directed against the first respondent. These reliefs are: A declaration that Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential elections held on 7th December 2020, was in breach of Article 63, Clause 3 of the 1992 Constitution in the declaration she made on 9th December 2020 in respect of the presidential election that was held on 7th December 2020. B, a declaration that, based on the data contained in the declaration made by Mrs. Jane Adokwe-Mensah, chairperson of first respondent and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. C, a declaration that the purported declaration made on 9th December 2020 of the results of the presidential election by Mrs. Jane Adokwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election held on 7th December 2020 is unconstitutional, null and void, and of no effect whatsoever. D, an order annulling the declaration of President-elect Instrument 2020 CI 135, dated 9th December 2020, issued under the hand of Mrs. Jane Adokwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election held on 7th December 2020 and gazetted on 10th December 2020. E, an order of injunction restraining the second respondent from holding himself out as president-elect. F, an order of mandatory injunction directing the first respondent to proceed to conduct a second election with petitioner and second respondent as the candidates as required under Article 63, Clause 4 and 5 of the 1992 Constitution. The language in which the first 4 reliefs, A to D, were crafted is suggestive that they were directed against the chairperson of the first respondent. However, the petition is not against her personally, but against the first respondent as an institution of state established under the 1992 Constitution. The article and rule under which the petitioner mounted the action are Article 64(1) of the 1992 Constitution and Rule 68A of the Rules of the Supreme Court, CR 16 as amended by CR 74 and CR 99. They provide as follows: 64 Clause 1. The validity of the election of the president may be challenged only by a citizen of Ghana who may present a petition for the purpose to the Supreme Court within 21 days after the declaration of the result of election in respect of which the petition is presented. Rule 68A, despite Rule 45(4), the parties in the petition shall be A, the petitioner as specified in Article 64, Clause 1 of the Constitution, and B, the person declared elected as president and the Electoral Commission, who together shall be the respondents. Though the petitioner is not in substance attacking the validity of the 7th December 2020 presidential elections, but only the declaration made on the 9th of December 2020, the petition is seen by many as a rehash of the presidential election petition of 2012-2013. In that petition, the second respondent herein, then as first petitioner and others, invoke Article 64, Clause 1, purportedly to invalidate the election of the petitioner herein, then as first respondent, as president-elect, as a novelty done in the constitutional history of the Fourth Republic. Answer JSC prefaced his judgment in that petition in the following words: Quote, the facts surrounding this suit have been fully played out in near epic dimensions before the public. However, there's no way this suit can be seen as a likeness of the numerous cases on various aspects of our 1992 Constitution. Indeed, I venture to say it cannot be compared to any of the cases touching on various aspects of our Constitution. By virtue of this peculiar nature and potential effects, many commentators have rightly described this suit as one posing a test of the structural maturity of our democratic ethos, causing all eyes worldwide to focus, even if only briefly, on our polity to see if and how we can surmount this unquiet challenge. Without doubt, the resolution of this case portends much for the future path of our democratic development. See, end of quote. See in presidential election petition, Akufo-Addo and Bawumia and Akufo-Addo, Bawumia and Obi-Chebe-Lamte, number 4, versus Mahama, Electoral Commission and National Democratic Congress, number 4, 2013, Supreme Court of Ghana Law Report, Special Edition, page 73 at page 151. Answer JS's description in the petition before the court in 2013 in the above words was apt, as that case remains one of the most important constitutional cases this apex court has determined in our current constitutional dispensation. It is therefore not strange that the attention that greeted the 2012 petition also gripped the instant one before us, thus placing the two seemingly similar cases on the same pedestal. The big question, however, is, are the two cases alike or do they present similar issues for determination? The answer in both questions is a big no. It is therefore not surprising that the petitioner in his closing address filed on 23rd of February 2021 admitted the similarity in the instant petition and that of 2012-2013. Background to the petition. On the 7th December 2020, the first respondent hearing, the Electoral Commission, which is the constitutional body established under Article 43 of the Constitution 1992 to conduct all elections and referenda in Ghana, conducted parliamentary and presidential elections in all 275 constituencies in the country, which are made up of 38,622 polling stations. The election was conducted under Public Elections Regulations 2020 CI 127. At the close of the exercise, the first respondent, through its chairperson, declared the second respondent, Nana Addo Dankwa Akufo-Addo, who was the presidential candidate of the New Patriotic Party, as the one validly elected as the President of the Republic of Ghana. This declaration was made on the 9th of December 2020, subject to Article 63, Clause 9 of the Constitution 1992 and Regulations 4410 D and 11 of CI 127-2020, an instrument, Declaration of President-elect Instrument 2020, CI 135, was published under the hand of the chairperson of the first respondent to that effect and published in the Gazette on 10 December 2020. The instrument reads, quote, in exercise of the power conferred on the Electoral Commission under Article 63, Clause 9 of the 1992 Constitution, this instrument is hereby made. Nana Addo Dankwa Akufo-Addo, the New Patriotic Party MPP presidential candidate, having in the presidential election held on the 7th of December 2020, pursuant to Article 63, Clause 3 of the Constitution, obtained more than 50% of the total number of valid votes cast, is hereby declared the President-elect of the Republic of Ghana. Given under my hand the 9th day of December 2020, signed Mrs. Jane Mensah, Chairperson of the Electoral Commission, end of quote. Article 63, Clause 9, on whose strength the instrument was made, provides, quote, an instrument which A, is executed under the hand of the Chairman of the Electoral Commission and under the seal of the Commission, and B, states that the person named in the instrument was declared elected as the President of Ghana at the election of the President shall be prima facie evidence that the person named was so elected, end of quote. The petitioner filed this petition to challenge the declaration made on the grounds of alleged errors and lack of transparency on the part of the first respondent in the correction of the said errors. The grounds for the petitioner's petition are that the said declaration violated Articles 23, 296, A and B and 63(3) of the Constitution 1982, and therefore unconstitutional, null and void, and of no effect whatsoever. These articles of the Constitution mentioned in petitioner's petition are those allegedly violated, for which the petitioner sought the release under paragraph 3A to F of his petition, which provides, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed on them by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal. 296A, where in this Constitution or in any other law discretionary power is vested in any person or authority, that discretionary power shall be deemed to imply a duty to be fair and candid. B, the exercise of the discretionary power shall not be arbitrary, capricious, or biased either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. 63(3), a person shall not be elected as president of Ghana unless at the presidential election the number of votes cast in his favor is more than 50% of the total number of valid votes cast at the election. End of quote. The petition itself. The petitioner, per his reliefs and grounds, is not challenging the data presented by the first respondent, from which the second respondent's declaration as president-elect was made. As a result of that, he has not presented to the court any figures to contradict the data of the first respondent. Petitioner's case simply is that the figures or data declared by the chairperson of the first respondent as the valid votes cast and those obtained by the two contestants, that is petitioner and second respondent, when computed, do not give the second respondent more than 50% of the said votes to merit her declaration as provided under Article 63, Clause 3 of the 1992 Constitution. The petitioner averred that the declaration was therefore unconstitutional, null and void. The petitioner proceeded further to seek an order to set aside an instrument affirming the declaration, that is CI 135, and a further order to organize a fresh rerun between the petitioner and the second respondent in compliance with Article 63, Clause 4 and 5 of the Constitution 1992. The above constitutional the above constitutional provisions were reproduced under Regulation 14, 1, 2, and 3, Regulation 44, 1, 2, and 3 of CI 127, and they read 63.4, where at a presidential election there are more than two candidates and no candidate obtains the number of percentage of votes specified in clause 3 of this article, a second election shall be held within 21 days after the previous election. 5. The candidates for a presidential election held under clause 4 of this article shall be the two candidates who obtained the two highest numbers of votes at the previous election. End of quote. From the nature of the relief sought in this petition, relief B appears to be the major relief on which the other 5 reliefs, that is A, C, D, E, and F, are buttressed. The success or failure of reliefs A, C, D, E, and F depend on the success or failure of relief B. For purposes of emphasis, we wish to reproduce petitioner's relief B. It reads, a declaration that based on the data contained in the declaration made by Mrs. Jane Adukwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election held on 7 December 2020, no candidate satisfied the requirement of Article 63, Clause 3 of the 1992 Constitution to be declared president-elect. This relief B, as quoted above, raises an arithmetical question. It cannot be resolved without resorting to some calculations. The first task is to know the data the first respondent presented, which the petitioner was referring to. The data will contain inter alia the total number of votes cast at the election, the total number of valid votes cast, the total number of valid votes cast in favor of the second respondent, and the total number of valid votes cast in favor of the petitioner. A percentage of each of the candidates is then calculated against the total valid votes cast. This is the only way to determine whether or not the second respondent obtained more than 50% of the valid votes cast or not, as the petitioner has challenged. In effect, If the petitioner is able to satisfy this court that the data contained in the declaration made by the chairperson of the first respondent did not give the second respondent more than 50% of the total valid votes cast in the presidential elections on 7 December 2020, then all the other relief sought under A, C, D, E, and F must be granted as a matter of course, as that would mean Article 63, Clause 3 has been violated, thus rendering the said declaration unconstitutional, null, and void. The petitioner, in advancing reason to support his petition, contended that the first respondent effected corrections to its original data as announced on 9th December 2020. The said corrections were null and void, as they do not reflect on the declaration made on 9th December 2020. Again, the first respondent did not indicate when the said corrections were made, and also did not involve the petitioner and his agents when making the corrections. The petitioner attached to his petition a pen drive of the video clip of the declaration made by the chairperson of the first respondent, a copy of CI 135, a copy of a press release issued by the first respondent on 10 December 2020, announcing the errors in the declaration and the corrections made, and a few other documents like summary and spreadsheets. According to the petitioner, the first respondent was not fair to him when he failed to engage his agents and to involve them in the corrections of the errors before the declaration. There was therefore no transparency in the corrections made, making the declaration and CI 135 unconstitutional, null and void, as same constituted a violation of Articles 23, 296A and B, and 63.3 of the 1992 Constitution. It is for this reason that the petitioner sought under Relief D an order annulling CI 135 and a further order directing the first respondent to proceed to conduct a second election between the first two candidates, that is, second respondent and petitioner, as the only candidates as required under Article 63, Clauses 4 and 5 of the 1992 Constitution. Clearly, from the nature of the relief sought in the instant petition, it is not identical with the 2012 presidential election petition. That petition sought to invalidate the presidential election conducted by the Electoral Commission by the annulment of over 4 million votes due to alleged irregularities such as overvoting, lack of signature of presiding officers on some pink sheets, no biometric verification in some of the constituencies. However, in this one, the petitioner is not seeking any such relief. He has not asked for the annulment of any votes cast anywhere during the election, and he has not said that the election was badly conducted. He is only seeking to annul CI 135 and a rerun between the candidates with the two highest number of votes, because the computation of the data presented by the first respondent does not give the second respondent more than 50% of the total valid votes cast. That is why PW1, the General Secretary of the NDC, Mr. Johnson Esedun Ketia, testifying under oath, told the court that they did not come to court to challenge figures, so they brought no figures of their own to this court. According to him, they were judging the chairperson of the first respondent by her own Bible, by which he meant they were judging her by her own data, from which the second respondent was declared president-elect. The first respondent case in answer. The first respondent denied petitioner's claim that from its data as presented in the declaration, the second respondent did not obtain more than 50% of the valid vote cast in presidential elections held on 7 December 2020. The first respondent admitted the petitioner's contention that it initially made mistakes in the figures announced on the 9th of December 2020 during the declaration by juxtaposing the total number of votes cast in the presidential elections with that of the total number of valid votes cast. However, this error was immediately corrected, and the correct figure mentioned in a press release the following day, 10th December 2020, and accordingly published in the official gazette. First respondent contended further that even with the error, the fact that the second respondent obtained more than 50% of the total valid votes cast was not in doubt, the first respondent prayed the court to dismiss petitioner's petition for disclosing no cause of action. The second respondent, case in answer. The second respondent also denied petitioner's case and describes him as incompetent and devoid of any substance whatsoever. He was of the view that even though petitioners said no candidate obtained more than 50% of the total valid votes cast and sought a rerun between the two of them, the petitioner did not indicate the number of valid votes or percentage thereof that she should have obtained in the election, or the number of valid votes or percentage thereof that the second respondent should have obtained in the election to support the allegations and requests for the rerun. He contended further that the corrections of the errors by the first respondent in her statement on the 9th of December 2020, annexed by the petitioner to her statement in support of the petition, were made within the authority of the first respondent and do not infringe any law. According to second respondent, the corrections effected by the first respondent in his press release of 10 December 2020 provided a proper reckoning of the percentage of votes obtained by the second respondent using the valid votes cast rather than total votes cast, and showed that the second respondent obtained more than 50% of the valid vote cast as required under Article 63(3) of the Constitution. He averred that petitioners' claims are anchored on an innocuous mistake made by the first respondent in interchanging total votes cast for valid votes cast when announcing the various percentages obtained by each candidate on 9 December 2020. Second respondent contended strongly that when the total valid votes cast are used as the yardstick, he would still be outright winner of the election by more than 50% of the votes, even if by statistical projection, the votes of all the 128,018 registered voters in Techima South were to be added to petitioner's votes. The second respondent averred further that if the total number of votes obtained by each candidate in Techima South is factored into the results declared by the first respondent on 9 December 2020, the second respondent's share of the valid votes cast is still well over 51%. In fact, the petitioner has no question in the petition. Second respondent denied allegations of violation of Articles 23 and 296 of the Constitution as misconceived. In the alleged vote pardon and the errors referred to by the petitioner, the second respondent, who denied same, contended that granted the allegations were true, they did not have any effect whatsoever on the result of the election. He said the alleged unconstitutionality of a declaration or gazette notification of an election does not constitute a challenge to the validity of an election of a person as president. He emphatically concluded that the petitioner has neither challenged the conduct of the election itself nor its validity, so his action is not an election petition properly so called and ought to be dismissed in limine. Second respondent served notice of his intention to raise a preliminary objection to the petition on the ground inter alia that the petition did not meet the requirement imposed on the petitioner under Article 64, Clause 1 of the Constitution 1992. He subsequently filed a preliminary objection, as the first respondent also did, for the dismissal of the petition on the ground that it discloses no reasonable cause of action in terms of Article 64, Clause 1 of the Constitution 1992. Though both the first and second respondents prayed the court to set down for legal argument their objections in limine to petitioner's objection, the court decided to hear the petition in detail and resolve the preliminary legal objection together with other issues raised by the pleadings of the parties. Issues set down by the court for determination. The court directed each of the parties to file a memorandum of issues for trial. The parties complied and filed issues they considered material for consideration. Out of those issues and the materials contained in the petition and the answers to the petition, this court adopted the following as the real issues arising from the pleadings for determination. 1. Whether or not the petition discloses any reasonable course of action. 2. Whether or not, based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid votes cast as required by Article 63, Clause 3 of the 1992 Constitution. 3. whether or not the second respondent still met the Article 63, Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techima South constituency presidential election results. 4, whether or not the declaration by the first respondent dated 9th December 2020 of the results of the presidential election conducted on the 7th December 2020 was in violation of Article 63, Clause 3 of the 1982 Constitution. And 5, whether or not the alleged vote pardon and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. Mode of trial. Since the rules of this court regulating presidential election petition trials, that is CI 16 as amended by CI 74 and CI 99, has a regimented timetable that include a scheduled date for pre-trial case management protocols, the court adopted the procedure in the High Court Civil Procedure Rules as amended by CI 87 on the filing of witness statements with exhibits, if any. The court accordingly directed the parties to comply by filing witness statements within specified periods. They were also directed to file their written submissions for and against the preliminary objection raised to the petition by the respondents. Though the petitioner defaulted initially in the direction to file witness statements and their answer to the legal submissions made by the respondents on the preliminary objection, they later complied when the court admonished them to do so within 24 hours or have their petition determined in accordance with the law. The petitioner, who did not file any witness statement of his own, filed witness statements of 2 witnesses he intended to rely on to establish his case. The first respondent also filed a witness statement of its chairperson, while the second respondent filed a witness statement through his attorney. Standard of proof, burden of proof, and persuasion. A petition of this nature is a form of civil litigation, and like all civil cases, the standard of proof is one on the balance of probabilities or preponderance of the probabilities. The proof prescribed in civil trials is provided under sections 10, 11, and 12 of the Evidence Act 1975, NRCD 323. These sections on the burden of proof, burden of persuasion, and burden of producing evidence, which apply equally to election petitions, provide us 10.1. For the purpose of this act, the burden of persuasion means the obligation of a party to establish a requisite degree of belief concerning a fact in the mind of the tribunal of fact or the courts. 2. The burden of persuasion may require a party A to raise a reasonable doubt concerning the existence or non-existence of a fact, or B to establish the existence or non-existence of a fact by a preponderance of the probabilities or by proof beyond a reasonable doubt. 11.1. For purpose of this act, the burden of producing evidence means the obligation of a party to introduce sufficient evidence to avoid a ruling on the issue against that party. 12.1. Except as otherwise provided by law, the burden of persuasion requires proof by a preponderance of probabilities. 12.2. Preponderance of probabilities means that that degree of certainty of belief in the mind of the tribunal of fact or the court by which it is convinced that the existence of a fact is more probable than its non-existence. End of quote. As was held by this court per additional JAC in Accra versus Pega Transport Limited, 2010 Supreme Court of Ghana Law Report, page 728 at 736. Quote, it is a basic principle of law on evidence that a party who bears the burden of proof is to produce the required evidence of the facts in issue that has the quality of credibility, short of which his claim may fail. End of quote. See also the case of IE versus Shell Ghana Limited and Fraga Oil Limited, 2017-2020, Supreme Court of Ghana Law Report 721 and 733, where this court, speaking through Benin JSC, had this to say, quote, it must be pointed out that in every civil trial, all what the law required is proof by preponderance of probabilities. See Section 12 of the Evidence Act 1975 and RCD 323. The amount of evidence required to sustain the standard of proof would depend on the nature of the issue to be resolved. The law does not require that the court cannot rely on the evidence of a single witness in proof of the point in issue. The credibility of the witness and his knowledge of the subject matter are determinant factors. See Ama vs. Hydrafoam Estates Ghana Limited, 2013-2014, to Supreme Court of Ghana Law Report 1551. Indeed, Even the failure by a party himself to give evidence cannot be used against him by the court in assessing his case. This court's decision in Ray Ashaliboche-Lance, Ajete Agbosu versus Kote, 2003-2004 Supreme Court of Ghana Law Report 420, per Judgement JSC as it then was at page 448, and Ama versus Hydra Foam Estate Ghana Limited, referred to Supra. In the last case cited, the plaintiff did not testify in the action at all, and only relied on the testimony of the court-appointed witness. Yet he succeeded, and this court considered the process valid, so long as the evidence relied upon was credible and sufficient to discharge evidential burden he assumed. Cases on election petitions in Africa and other common law jurisdictions give credence to the notion that in such cases, where a petitioner seeks to annul an election or a declaration pertaining to an election, he bears the legal burden of proof throughout. See Abu Bakr versus Yaaldua, 2009, all FWLR Part 4571 Supreme Court. Odinga versus Uhuru Kenyatta, 2012, petition number 5. Opis versus Reneski, 2012, SCC 55. Biseji versus Museveni, Yoweri Kaguta, and Electoral Commission of Uganda, 2012, UGSC. 2001, Uganda Supreme Court. In the Ugandan case of Besege versus Museveni and Electoral Commission of Uganda, Supra, the Uganda Supreme Court held, quote, the burden of proof in election petitions, as in other civil cases, is settled. It lies on the petitioner to prove his case to the satisfaction of the court. And in the Yaaldua case, the Supreme Court of Nigeria held that the burden is on the petitioner to prove not only non-compliance with the electoral law, but also that the non-compliance affected the results of the election. End of quote. This court adopted the same principle in the first presidential election petition titled Ekufuado, Bawumia and Obechebe Lamte versus Mahama and Electoral Commission, number 4, 2013 Supreme Court of Ghana Law Report, Special Edition, page 673. The trial itself, evidence led by petitioner. The petitioner did not testify himself and appointed no attorney to testify on his behalf, but called 3 witnesses in all. They were Mr. Johnson, Esiedun Ketia, PW1, Dr. Pesa White, PW2, and Mr. Robert Joseph Mertel-Nunu, PW3. Under the law, the petitioner is not bound to testify himself if only he could prove his case through other witnesses or by any other means. See the case of Ray Ashaliboche, Lance, Ajete Agbosu, and others, Escote, and others, Supra. We know of no law in the common law jurisdiction, especially in civil trials, that mandates a court to compel a party to testify against his will. The failure of the petitioner to testify himself is therefore not fatal to his cause, as the law permits that. What is required from him by law is for him to call requisite witness or witnesses or put before the court sufficient material as evidence. Initially, the petitioner indicated calling 2 witnesses, so only 2 witness statements were filed on the orders of the court. These witnesses were PW1 and 2. After the 2 witnesses had completed their testimonies through the adoption of their witness statements and cross-examination, the petitioner prayed the court to permit him to call a 3rd and final witness to conclude his case. Though the prayer came at a time the petitioner had not given any prior indication of such an intention, for which counsel for the respondents raised objection to the move, the court obliged him and made an order for a witness statement to be taken from his witness to enable him to testify for the petitioner. The petitioner did so and closed his case with the witness who testified as PW3. Out of these 3 witnesses, the one whose testimony appeared to have some relevance to the issues at stake was Mr. Johnson Esiedun Ketia, PW1. He was, in fact, the star witness of the petitioner. His testimony vividly explained the reasons why the petitioner is in court. As for the other 2 witnesses, that is PW2 and 3, Dr. Pesa White and Mr. Robert Joseph Mertel-Nunu, the little said about their testimonies relative to the issue at stake, the better. PW2 and PW3 were agents who represented the petitioner in the National Collation Center dubbed the Strong Room. Their testimonies were based mainly on what allegedly happened in the Strong Room during the final collation and the fact that they failed to sign the final form of the presidential election scored from 13 because of disagreements they said they had with the chairperson of first respondent and her staff in the strong room. They recounted a fanciful tale of how the chairperson refused to heed their complaints on some irregularities they noticed in some of the coalition forms that came from some of the regions. We describe this evidence as fanciful because despite these alleged protests, they went ahead to verify and certify 13 out of the 16 election regional coalition seats. Their testimony included an account of how the chairperson of the first respondent managed to trick them to leave the strong room by sending them on an errand to confer with the petitioner, during which period he declared the result of the presidential election without their participation. While the testimony of PW1 was emphatic that the petitioner is not in court to challenge or compare the figures or data presented by the first respondent with any other figures, the testimonies of PW2 and PW3 were in respect of alleged irregularities in the figures or data on some of the regional coalition forms that they cited in the strong room, but which they ultimately signed or certified. Notwithstanding all these allegations of misunderstandings with staff of the first respondent in the strong room and the fact that they were absent during the declaration, they did not give any indication as to how these happenings and the absence affected the final results announced by the first respondent. Having signed or certified these forms, the witnesses, particularly PW3, cannot turn around to talk of irregularities in the said forms. Their testimonies would have carried some little weight if the purpose of the petition was to challenge entries made on the coalition forms or summary sheets, but that is not the case. Their testimonies were therefore of no relevance whatsoever to the issues set down for determination, and we found them unworthy for any consideration whatsoever in the settlement of the issues. In fact, regarding the testimonies of PW2 and PW3, if their evidence is to be believed, then they have to blame themselves for abandoning their post at the National Coalition Center at the time the verification and certification of the results were ongoing, and PW3 had then verified and certified 13 regional coalition results out of the 16. The agents of the petitioner were given the opportunity to be in the strong room. In addition, the petitioner had 2 additional agents as backup or standby. PW2 and PW3 were not under any obligation to leave the strong room under any circumstances. Besides, other presidential candidates had their agents or representatives in the strong room, and 8 of them signed from 13. If the petitioner's agent believed that in their absence something untoward happened, the petitioner should have called any of the other agents in the strong room to testify in court any infractions that happened in their absence, if any. The law is that when corroborative evidence exists, the law is that where corroborative evidence exists, the law expects a party to call such evidence in proof of his case and not mount the witness box and repeat his averments on oath. The dictum in Mojalagwe versus Labi, 1959, Ghana Report 190, per Ole Nuje as he then was, a still good law. The petitioner's agents were given the opportunity to represent petitioner in the strong room, and they decided to leave. They cannot complain now that the declaration was done in their absence. With respect to the duties of party agents or representatives, we refer to the Kenyan case of Amolo Odinga and another versus Independent Electoral and Boundaries Commission and 4 others, number 2 of 20th September 2017, where Ngokis Ndongu SCJ opined that once the Constitution gives citizens the right to vote, the freedom to choose, and conditions are created for the realization of that right, it is not the business of the court to aid the indolent. If party agents are required to be present, sign statutory form, and undertake any other legitimate duty that is imposed upon them as part of the political process in an election, then they are under obligation to do it. To fail to do so is not only to fail one's party, but also to fail our democracy. The courts must frown upon any such inaction, reluctance, and delay. A candidate or her agent cannot abscond duty from a polling station and then ask the court to overturn the election because of a failure to sign a statutory form. Every party in an election needs to pull their own weight to ensure that the ideals in Article 86 are achieved. That we shall once and for all have simple, accurate, and verifiable, secure, accountable, transparent elections. Again, in the Nigeria case of Atiku Abubakar, the Independent National Electoral Commission, and Buhari, Supra, Mohammed Lawal Garba, JC, stated as, it is pertinent to restate that from the evidence of all the witnesses called by the appellant, they admitted that their polling agents signed all the result sheets, and this so voluntarily on the instruction of their party, the first respondent. The implication is therefore obvious, as it would have authenticated the validity of the documents. In other words, the result sheets. The agents in law were all presumed to understand what they appended their signatures thereto. They could not in the circumstances have turned around to deny the contents of their signatures. End of quote. Evidence of PW1. Regard to the first witness PW1, the government of his evidence as per his witness statement after the court had expunged some portions of same upon objection raised by the respondent is captured in the answers he gave during cross-examination by counsel for the first and second respondents. According to him, the petitioner did not come to court to challenge the validity of the figures or data presented by the chairperson of the first respondent. That is why in his testimony, he did not provide any data to contradict that of the first respondent. His assertion was that the figures initially collated by the chairperson contained errors, which his party, the National NDC, the National Democratic Congress, pointed out in a letter addressed to the chairperson on the 9th of December 2020 before the declaration. However, in effecting corrections to the wrong figures or data, the first respondent did not invite them for their participation, but unilaterally effected the said corrections contrary to Articles 23 and 296A and B of the 1992 Constitution. The question is, what is the legal implication, if any, of first respondent failure to involve the petitioner and his agents in correcting administrative or clerical errors made in the computation or the declaration? Neither the petitioner nor his witnesses mentioned any to us, and we do not find any. The court has held in several cases, including the recent ones of Gregory Afoko versus Attorney General, writ number J1/8/2019, dated 19 June 2019, unreported, and Mayor Ablese and two others versus Attorney General, suit number J1/28/2018, dated 28 November 2018, unreported, that breaches or violations of Article 23 on administrative justice and the exercise discretion under Article 26, the exercise of discretion under Article 296 of the 1992 Constitution by administrative bodies, which includes the first respondent, are not matters for the Supreme Court. These are infractions that the petitioner could have sought redress in the High Court. To quote Mafusam JSC in the Afoko case, Supra, Article 23 of the Constitution deals with administrative actions, and even where a breach of that provision is alleged, the remedy lies in the High Court and not this court. Article 23 is part of Chapter 5 of the 1992 Constitution on Fundamental Human Rights and Freedoms, which by Article 33, 1 and 2 of the Constitution ought to be enforced in the High Court. End of quote. See also Eduse versus Attorney General, 1996-97, Supreme Court of Ghana Law Report, page 1, and Eduse versus Attorney General number 2, 1997-98, Supreme Court of Ghana Law Report 753. On the exercise of discretion under Article 296 and alleged breaches or violations of sin, this court in the Mayor Ablese case, Supra, held per Koti JSC as follows. Throughout the Constitution, discretion has been vested in persons or bodies charged with his responsibility to exercise one power or the other. Where the discretionary power is not exercised according to law, the recourse by an aggrieved party lies in some other remedy provided for in the Constitution, and not an invitation to invoke the original jurisdiction of this court. End of quote. Though the two authorities cited above involve the invocation of the original jurisdiction of this court under Articles 2(1)b and 131 of the 1982 Constitution, the same applies to an election petition. The first respondent is an independent body that performs its functions without anybody's directions or assistance. Article 46 is specific about this. It reads, except as provided in this Constitution or any other law not inconsistent with this Constitution, in the performance of its functions, the Electoral Commission shall not be subject to the direction or control of any person or authority. End of quote. There is no dispute that the first respondent complied with Article 296 Clause C when it published the regulations CI 127. By this publication, the first respondent did not breach Clause B of Article 296, as its actions were not capricious and arbitrary. They were regulated by CI 127, and there is no complaint anywhere by the petitioner that the first respondent did not comply with CI 127. If it is the case of anybody that the first respondent violated Articles 23 and 296 in the discharge of his duties, which included the declaration of the presidential results under Article 63 Clause 3 of the 1982 Constitution, the remedy of that person lies in the High Court, because strictly such a complaint cannot be an election petition challenging the validity of the election of the President of Ghana. The respondent case. At the close of the petitioner's case, the respondent decided or elected not to testify at the proceedings. They relied on Order 38, Rule 3E5 of the High Court Civil Procedure Rule CI 47 as amended by CI 87, which the court adopted to regulate the trial in addition to the rules provided under CI 16 as amended by CI 74 and CI 99. The respondents prayed the court to decide the issues before it on the strength of the oral and documentary evidence led by the petitioner through his witnesses. This decision by the respondent, which is not a novelty but accepted as settled practice, attracted strong opposition from counsel for the petitioner, who insisted that the chairperson of the first respondent must be made to testify for her to be cross-examined. All the attempts employed by counsel for the petitioner, which included an attempt to reopen petitioner's case, for him to subpoena the chairperson of the first respondent to testify for him as a witness, and an application to review the court's ruling on respondent's decision not to call evidence, which were all resisted by counsel for the respondents, were dismissed by the court. You would like to reiterate the point made above that in law, the step taken by the respondents has the sanction of time-honored and settled practice in our adversarial system of justice. The position of the law is that after the close of the plaintiff or a petitioner's case, a defendant or a respondent for that matter has three options open to him. The defendant or respondent may elect to open his defense and call witnesses if he so wishes. Secondly, the defendant or respondent may elect to rest his case on the plaintiffs or petitioners when he is of the view that the case of the plaintiff or petitioner is weak and has failed to raise a prima facie case to warrant the defense to answer. Lastly, the defendant or respondent may elect to make a no-case submission, whereupon he may be put to an election by a trial judge. There is no case submission. This no case submission, is to the effect that even if the whole of the evidence led by the plaintiff is admitted, there's no prima facie case made out by the plaintiff or petitioner. Mohammed Lawal Garba, JC of the Court of Appeal of Nigeria, in the presidential election petition between Atiku Abubakar and another versus Independent National Electoral Commission, INEC, and two others, petition number CE/PEPC/002/2019, dated 11 September 2019, stated, quote, the third position of the law is that a defendant to an action or a respondent in an election petition is entitled to rest his case on that of the claimant or the petitioner, where he has, through devastating cross-examination, elicited or extracted sufficient evidence to support and prove the facts or assertions contained in his pleadings. In such circumstances, a defendant or respondent can decide not to call any witness. It does not amount to not calling evidence or failure to call evidence. End of quote. The Nigerian court of appeal in coming to this above conclusion relied on the dictum of Justice Kekri Ikun JSC in the case of Pastor Eze Inyan, Andrew and another, that's INEC 2018 9 NWR Part 1625507 at 582 AM, where the Supreme Court held, quote, evidence elicited from a party or his witness under cross-examination which goes to support the case of the party cross-examining constitute evidence in support of the case or defense of the party. If at the end of the day the party cross-examining decides not to call any witness, he can rely on the evidence elicited from cross-examination in establishing his case or defense. One may, however, say that the party called no witness in support of his case, not evidence as the evidence elicited from his opponent under cross-examination, which is in support of his case or defense, constitutes his evidence in the case. The exception is that the evidence so elicited under cross-examination must be on the facts pleaded by the party concerned for it to be relevant to the determination of the question or issue in controversy between the parties, having regard to the fact that the relevant evidence elicited from the appellants relate to the facts pleaded by way of defense to the action. They form part of the respondent case and can be relied upon by the respondent in establishing their defense to the action without calling witnesses to further establish the said defense. End of quote. This court, therefore, after the respondents have decided not to call witnesses, directed the parties in the petition to file their closing addresses or submissions for consideration of the court in resolving the issues set down for trial. Submission by petitioner and the respondent. The respondent filed their witness submissions as directed by this court on 17th February 2021. Petitioner, on the other hand, did not comply with the directives of the court to file his closing address or submission by the close of 17th February 2021. He, however, later sought leave of the court to file it out of time, which the court granted. He therefore filed his submission or closing address on the 23rd of February 2021. We shall refer to the relevant portions of the submissions or closing address when necessary in addressing the issue set down for determination. Evaluation of the evidence on record and the decision of the court. This court set down 5 issues for the determination. They were: 1, whether or not the petition discloses any reasonable course of action, whether or not, based on the data contained in the declaration of the first respondent of the second respondent as president-elect, no candidate obtained more than 50% of the valid vote cast as required by Article 63 Clause 3 of the 1992 Constitution. 3, whether or not the second respondent still met the Article 63 Clause 3 of the 1992 Constitution threshold by the exclusion or inclusion of the Techi-Mansal constituency presidential election results. 4, whether or not the declaration by the first respondent dated 9 December 2020 of the results of the presidential elections conducted on the 7 December 2020 was in violation of Article 63 Clause 3 of the 1992 Constitution. Whether or not the alleged vote padding and other errors complained of by the petitioner affected the outcome of the presidential election results of 2020. We shall now address the issue settled for determination in this petition. Issue 1, reasonable course of action. The first issue is whether or not the petition discloses a reasonable course of action. Though this issue was raised by the respondent as a preliminary point, the court decided to deal with it alongside the determination of the substantive issues settled for the trial. The court accordingly ordered the parties to file their respective submissions on this issue. The case of the respondent on this issue is that examining the petition and considering the reliefs thereof, no reasonable course of action has been raised to properly invoke the jurisdiction of the court under Article 64 of the 1982 Constitution, and for that matter, the petition should be dismissed summarily. According to the respondent, the petition does not challenge the voting process and the counting of ballots, neither does the petition challenge the collation of votes from the polling stations through to the National Coalition Center and the declaration of the results of the presidential election. The respondents argued further that the thrust of the petitioner's complaints relates to the errors contained in the declaration of the winner of the presidential election by the chairperson of the first respondent on the 9 December 2020 and the subsequent correction of the errors. The respondent posited that the facts alleged in the petition and reliefs thereof do not meet the threshold of challenging the validity of the presidential election as envisaged under Article 64 Clause 1 of the 1992 Constitution. The petitioner opposed the perennial objection and argued that the petition discloses a course of action against the respondent. The petitioner argued, for example, that the petition alleges that the figures used by the chairperson for the first respondent to declare the results was in breach of the Constitution, that the figures supplied by the first respondent did not at all reflect the actual results of the elections, that the first respondent officials padded votes in favor of the second respondent, and also alleged wrong aggregation of votes. The petitioner therefore submitted that the objection be dismissed. It is right that a party such as the petitioner who initiates an action in court against another person must have an accrued cause of action. A cause of action is the existence of facts which give rise to an enforceable claim or a factual situation, the existence of which entitles one to obtain from the court a remedy against another. Generally, before a party issues a writ, he must have a right recognized in law, which right has been violated by the defendant. In ascertaining whether the petition, the subject of this action, discloses a reasonable cause of action, it is important that the court critically examine the petition so filed, in particular the grounds, the reliefs endorsed therein, and the answers filed by the respondents, for the court to satisfy itself that on the face of the petition, tribal issues have been raised. These issues could be issues of fact, law, or both law and fact. We think that once the court is satisfied that the issues raised in an originating process, such as a petition or a writ, is not frivolous, then a cause of action has been disclosed to invoke the jurisdiction of the court. In the case of Dasibre Asariba II and 4 others versus Attorney General, 2010 Supreme Court of Ghana Law Report 463, this court, speaking through Judge Nawood CJ, stated that to identify the real substance of actions brought before the court, we have observed that the proper approach is to examine the writs as well as the pleadings in this type of litigation, the reliefs and the facts verified by the affidavit. End of quote. Further, it is always the duty of the court not to assume jurisdiction over a suit where the court has no jurisdiction over either the subject matter of the suit, the parties to the action, or where a party to the suit is not clothed with capacity regarding the subject matter in issue. Again, a court may not assume jurisdiction over a case where issues of limitation, estoppel, per rem judicata are raised and proved as preliminary points. In the circumstances of any of the above being applicable, the court ought not to assume jurisdiction to determine the merits of the case before it. In the absence of the existence of any of these factors, the court decided to incorporate its ruling on this issue in its final judgment. In this petition, the petitioner was one of the candidates who contested the presidential election held on 7th of December 2020, and thus had the right to challenge the validity of the results declared by the chairperson of the first respondent if he is so aggrieved. The petitioner by this petition is challenging the act of the chairperson of the first respondent, declaring the second respondent the winner of the elections on grounds that the second respondent did not cross the constitutional threshold of more than 50% votes. The petitioner has also alleged wrong aggregation of votes and vote padding by officers of the first respondent in favor of the second respondent. We are of the opinion that these allegations relate to the integrity of the election, and if proved, may impact the validity of the election. The allegations thus provide enough grounds for the invocation of the jurisdiction of this court and Article 64 of the 1992 Constitution, and thus confer on the petitioner a course of action to initiate the action.